May I please? I'd like to mention item number 7 and 8.
7 and 8.
Yes. Here in item number 8, we are filing an IA. Kindly it may be taken up one day.
In which item you are going to file IA?
In item number 8. For implement.
For implement.
Implement. So kindly it may be taken up on Monday.
I cannot say, lots of cases are already fixed.
Let them file the IA and accordingly it will be listed here. It's only for the implement. It's not necessary. It should be listed on Monday. Any date, any individual date.
List accordingly, it was click of Hart so and so and Mr. So and so. In 8 cases submitted by learned counsel for the petition that we are going to submit and file an IA for implement of the party. So prayer allowed. Let the matter be accordingly listed after filing of the same IA. List accordingly. Other one,
Item number
Say-
7.
7, it's not connected one.
No, not connected. This will be kindly listed or.
I would like to mention item number 6.
6.
Your Lordship, item
But
number
this is
5 and 6
5 and 6
are connected.
5 and 6 are connected actually. You are not appealing for 5?
Yes, my lord.
Huh?
Item number 6.
No, 6. If 5 you are not appealing,
No,
There-
no, no, ma'am.
Therefore, the private.
I'm for the response number 2, ma'am.
Therefore,
they
the
are for the
private.
private response.
Yes.
Counsel for the petitioner is.
Counsel for the petition. You are for the petitioner.
Yes, ma'am. Item 5, I'm for that.
5 and 6.
No, only in 5.
You are on 5. You are also private respondent.
No, I'm for the petitioner in item 5.
You are a petitioner for item 5 and
In item number 6, I am for the petitioner, you know.
item number 6 you are for the petitioner. In item number 5 only state is there or other?
Both the parties are there.
Parties. They are yet to file their workout number in item 5.
So you are seeking adjournment for why?
Senior counsel is like out of station due to the medical problem. Leave of application has been submitted, my lord. K. Lolen, yes.
Ground to deal with both 5 and 6. So ekalage both 5 and 6 will be on medical ground.
Yes, madam.
So suppose 4 weeks will 4 weeks.
3
will
weeks,
be
3 weeks will
sufficient.
do, madam.
List after 4 weeks.
Obligation.
You'll record your respective names in the council.
Interim.
May I, Lordship? Lordship, I beg to mention item number 21. I am for the respondent.
Hmm.
Lordship, this matter is fixed for final hearing, so a fixed date may be kindly be given.
Fixed for final hearing,
Yes,
but one I has been filed, I think. One I is here, you see 185. I is for what? So that's why most really, now otherwise also it is fixed for hearing only.
Yes,
supplementary
ma'am.
hearing. So you need some time.
yes, my lord, a fixed date may be given.
Why?
Because today the senior counsel is not
You're
present,
for the appellant,
for the respondent.
for the respondent. R. Sonar is absent.
Yes, he is in another court.
Another,
He is, I mean, today he will not be able to be present here. He's out of station in another district.
Just after 3 weeks. Another district.
Yes.
So leaving the matter in the High Court, he is appearing in the other district.
My lord, it was urgency, that is why. Much obliged.
Mayor Lordship, I beg to mention item number 2.
Two.
2, yes.
Yes, why?
Leading council
By today or?
today is already in process.
And it's under process. Listing matter accordingly. Will be after 1 week only, otherwise we don't have 1 week, after 1.
And my lord, there is interim order, my lord.
Interim was there, interim we continue in next.
No problem, my lord.
May I, Your Honor? Your Honor, I'd like to mention item number 16 and 17. The leading counsel, who is the petitioner in this case, he is out of station. So this matter may be listed after 4 weeks.
Who
And
is your leading counsel?
it's Tabatagum.
He is not available,
Yes, Your Honor,
out of station.
out of station, Your Honor, and we have taken the consent of the other parties. And meantime, the interim order may be continued.
In 16 and 17, Mr. T. Tabu is out of station, both in both the cases. So and so, and go to this after it is the 23 matter is 4 weeks.
And Your Honor,
Was there interim
yes, Your Honor,
in both the matters? Interim was there?
yes, Your Honor,
Interim be continued in both the matters till the date of listing.
obliged, Your Honor.
May I please, my lord? My lord, I beg to mention an unlisted matter. It's an IA for correction of typographical error. It may be taken up today.
Who taken?
Obliged.
May, my lord, I beg to mention item number 18.
Hmm.
My lord, today I file wakalatnama in the so
On behalf of respondent,
respondent number 2
respond number 2.
in item number 18. So same may be brought into record, my lord.
It is not already, I have gone, I know, it has not received, no? In 18. it was in order column, so you have already appeared. So it can be listed for admission hearing.
No,
In
my
the
lord,
meantime,
let the matter,
Wakalatnama will come, so then.
well, let the
Or
matter,
is there any?
my lord, let the matter maybe come today. It's okay.
As
Got it.
far as I have been informed, your lordship, uh, he's saying that let the matter reach in that case. Serial,
Acha. Then okay, thank you for the
Much-
Yes.
May I, please, Madam, I would like to mention item number 14, Madam. Madam, due to some personal difficulty, Madam, I will have to leave the court premises now, Madam. So here I'm appearing to a petitioner, Madam. I've taken steps upon the sole respondent, Madam, and I've checked the office records, Madam. The service is still awaited, Madam.
Still away.
Yes, Madam.
But Mr. Swens, this would be the learned counsel appearing for the petitioner. Received the answer of the. Then appears on call for the appellant. Answer has already been received. Let the matter be listed according to for admission hearing or after 2 weeks.
May I please your lordship? Your lordship, I have filed this criminal petition against an interim order where I have been denied by the learned CJM Teju. The order dated 9/12/2022. That is in page number 65 to 69. Now, the fact of the case is this, Your Honor, Your Lordship, that I have been outed by the respondent on on the month of May 2021. Thereafter, I have filed a maintenance case before CJM Rowing, wherein I have maintenance has been granted, interim maintenance granted to my daughter, but not been granted to me without assigning any reason. Thereafter, Your Lordship, I have filed a criminal petition before the Session Judge Teju. And the Session Judge Teju, Your Honor, may look at the page number 60 to 64, the order of the Session Judge Teju, Your Lordship. Now, 64, the page number 64 on the order portion, it has been written that in view of the above discussion, the last part of the impugned order, whereby the learned court below declined to pass interim maintenance to the applicant wife, is quashed and set aside. The learned court below is directed to reconsider the prayer of interim maintenance of the applicant wife by hearing the learned counsel of both the parties by passing reasoned order. The learned court below shall consider the prayer of granting interim maintenance to the applicant wife, petitioner, expeditiously as possible in compliance with the guideline issued by the Honorable Apex Court in Rajneesh versus Nia. Thereafter, Your Lordship, the hearing has been took place. Then, after that hearing, I have been denied of interim maintenance, and that is on page number 65 to 69, the impugned order, Your Lordship.
Your Honor, I am for the respondent, and already maintenance was given for the daughters, and moreover, she is earning, Your Honor, and she's getting the benefit of her late husband.
But I will
around 26,000. I annexed that payslip, Your Honor, on this my.
No, whatever, after the direction of the session judge, most probably matter was again heard.
Yes.
And after hearing the same, again the prayer for interim was rejected.
Yes. No.
and in affidavit it has been written something else. And in this written, in this affidavit, what they have filed before your honors court, they have, it has been filed that he has been paying.
Your Honor, that.
Facility.
Yes.
He has been paying rupees 5,000 to his previous son, to his daughter, everything. 5,000 to his daughter from his previous marriage and son from his previous marriage, always to his mother, but no any evidence has been proved. That to your lordship, the respondent have submitted a slip where I have been showing that I am getting a pension of rupees 26,000 without any seal and sign of the bank authority. If you want to look at the document furnished by them, you know, it's a proven fact that if my account, nobody can access my account, what I'm earning, then I can access anyone. I can access my London council account that what is earning. It is and at that point of time, I am getting a pension of 26,000, 24,900, out of which 6,800 has been taken on, has been debited from my loan account. And the loan has been taken, that is admitted in the written objection by the respondent. The loan has been taken by me for clearing the outstanding car dues of the respondent when he has taken in the year 2020. It has also been admitted in the written objection. Now, from the previous marriage, I have a son who is at class 10, your lordship. So from that mere 18,000, I have to manage my son who is in class, his educational expenses, my personal expenses. He is going to karate classes, everything, your lordship, everything, the school fees, tuition fees. They have given for better coaching. I have given to a better institute in Teju for scoring high marks in the exam, in the matriculation exam. And he is only giving 5,000 to my daughter. Now, you are considering all the aspects, your lordship, or lordship may pass interim maintenance. And I have a ruling of High Court of Delhi and High Court of Rajasthan, where it didn't say that even if the wife is earning, and wife is entitled for maintenance, your lordship, interim maintenance. If you're honorable, I have.
Good. Yes.
May I, Your Honor?
Yes.
Your Honor, this matter is still pending in the subordinate court at the Rowing. So one need to be examined, proper appreciation of the witness and evidence is necessary. So my humble prayer is that Your Honor may provide this matter to the CGM so that final hearing may be given over there, and so the settlement will be over there to the CGM court. So whatever says at in the judgment of effects given by FX Court in the Rajneesh was as they pray for the asset and liabilities, I have clearly shown in my affidavit in opposition, Your Honor. That is already I clearly shown everything that whatever I have possessed and whatever I have been. So, Your Honor, my humble submission is that this court will interfere in this matter, and this further, Your Honor, the maintenance the legislature has not enacted the law of maintenance to just torture a husband from not giving maintenance to the wife. It doesn't mean, Your Honor, that and moreover, I'm giving the monthly maintenance to my daughter, and she's earning moreover from her late husband, that's 26,000 around that. I have put the annex that pay slip in the my affidavit opposition annex shall be page number 20. May kindly look at this as a record, Your Honor. And moreover, Your Honor, rejection of interim prayer did not delude the petitioner from getting maintenance later on. So let that it may decide by the subordinate court, Teju. So hence this, I humbly pray, I respectfully pray to this court, hence this interim maintenance petition may be liable to be dismissed.
Now to death contest, your lordship, the asset and liability they have filed on the subordinate courts is totally false of that. That's the reason we have filed a 340 petition over that court as well for swearing and false affidavit based on
Why you have said that these are all false documents?
That's why, Your Honor, moreover they have.
No, your lordship, I have.
That's why they are contradicting all this.
No, your lordship, they have filed over there because if you honor have a look in there.
The admitted fact is she is getting pensions.
Pension, yes, here. It's not a disputed fact. We have also mentioned your asset liability that I am getting the pension. But that pension I have to manage my son as well, Your Honor, to my chief as well.
That is all.
Interim maintenance.
Your Honor. Moreover, he is giving
even
absurd submission.
Rajneesh versus Neha, it has been dealt that even if the wife is earning, she is entitled to get the maintenance, your lordship. All the fact may entry may be granted, your lordship.
So your honor may, I'm just praying your honor once again that proper witnesses and evidence is necessary to, your honor, appreciate in the lower court. Because case
Two and three, one is statements.
Yes.
One is state, 2 and 3 are there, so, sorry.
Today I have filed Wakalatnama.
Today you have filed wakalat. So now it is in order for, so it can be listed for admission method.
Your lordship, here my only concern is the original LCR is there in the court, your lordship. And there is no any stay order as such. So therefore, your lordship, the original LCR may be sent back and copy of the same may be retained, your lordship. Because there is no any stay.
The registry can do this? No, he is saying that LCR, original LCR have received though. So one copy may be prepared here at the registry and then original can be.
Yes,
sent.
yes.
There is no stay order.
Yes, your lordship.
I heard Mr. LCR may be returned to the court. Court below. Please the matter accordingly after. It will be after 1 week. Yes,
After 1 week.
just after 1 week.
Is reflected in the order column, but it was fixed for hearing, your lordship, for final exposure, criminal appeal.
It should be fixed for hearing only.
Yes, your lordship. Last occasion, your lordship, actually they are placing the IA application, the 389, and it was applies to the
I for what?
389 for suspension of sentence.
389. So otherwise case is ready for final hearing.
Yes.
Yes, your lord.
Matter is ready for final hearing. So with that view on the last occasion, this was fixed for the hearing. So this should have been listed in the government report. But as part of that also. My lord.
Your lordship, we are ready, your lordship.
My
Based
lord,
upon the petitioner, your lordship, and this convenience of the court as well, your lordship.
my lord, my lord. My lord, I'm on behalf of petitioner in item number 11. And I'm on behalf of Mr. N. Ratan. My lord, this matter was earlier taken up by Mr. N. Ratan. But now he is unable to take up this matter because he is being inducted or appointed as additional advocate general for Arunachal Pradesh. So my lord, this matter may be taken up by some council, some other council. So some time may be given for at least 3 weeks. So that the leading council will argue in this matter.
Yes,
Item
some
number- yes,
genuine
my lord.
problem, I
Item
think.
number 10 and 11 are the, my lord, out of the same PS case. And out
That's
of the
why-
same case.
Yes.
Yes,
So I
so
am
both the
referring to
matters
that.
maybe should be heard together. because
Together,
that
yes,
will be
Your Lordship.
confusing.
That will be more.
Now, he is having a genuine problem, I think, because Mr.
And
R. Ratan, who was appearing for the appellant.
Yes.
Now he is not in a position to appear. So have you taken any steps to engage any other council?
Yes, my lord,
There
leading
should
council.
be a step taken because it's okay, he cannot appear now, but what about the engagement of the other council?
Yes, my lord,
Much more time,
okay, ma'am.
because his position is that he will still behind the back.
Okay.
So that is it. So. Item number 10. Item number 10, you simply write, Mr. C. Modi and so and so. In item number 10, is there any other council for respondent number 2 or the private respondent?
Yes. Yes.
Most probably one name is shown here, H. Lam.
Yes, yes,
You're
yes.
appearing. Name this him also. And list the matter accordingly for the final hearing after 2 weeks. Simple order, put it okay to. And in
My,
other.
Lordship, we have taken steps. Again, we have taken steps to respondent number 4, 5, and 6.
4, 5, and 6. So what is the position now? Notice upon 4, She are represented by the government. Yes. Heard Mr. Anand PSC. Your good name was?
Yes, Iran.
Heard Mr. S. Iram. Your name is not reflected, no? As Iram, the learned counsel, on behalf of the petition. From the office note dated 1/8/2023, it reveals that the notice on response number 4, return answer. However, the service on response number 5 and 6 are still awaited. Let the service be awaited for response number 5 and 6, with a direction to take fresh steps on response number 4. Earlier, we have taken step through registered AD.
Yes. Where is that?
Registered AD. So it return answer, so it is a criminal matter, no? So you can, this time you can take steps through the jurisdiction police station. This may help you. Through OC of the Council Police Station. Let the matter be accordingly listed after 4 weeks. You want to withdraw this one?
Yes. As per the order dated 22/06/2023, for directed the petitioner to approach the appropriate forum. And petitioner approach the appropriate forum by filing appeal number 147 of 2023 before the civil judge senior division Pasighat.
We have already filed. You are Mr. M.E.T. The learned counsel appearing on behalf of the petition. And it is submitted that as per the observation made by this court dated 22/6/2023, they have already approached civil judge. Civil judge in Swiss district.
Senior division
Civil judge senior division,
Pasighat.
Pasighat. With her, what kind of petition is a civil?
Civil appeal.
Civil appeal. Civil appeal.
Yes, sir.
And already approached the learned civil judge senior division, which is civil appeal, and hence he, in view of this, he wants to withdraw the present petition. They are allowed according to the present petition is disposed of. It will be withdrawn. Which Wakalatnama Panchayat? Wakalatnama is there? You are on Wakalatnama, no?
Yes, my lord.
Okay, anyway, whatever is, yes,
My lord, I put a respondent number 2.
yes, we have already appeared on this one.
Case, my lord, it relates back to 2009. And there is political, of course, difference. And therefore, the FIR, it was lodged by the complainant only to harass the accused here. Now, after that, in the year 2014, both of the parties has settled the issue. Although during filing of this criminal petition.
Matter has already been settled.
Yes,
So it is already settled.
Yes, my lord. I have no objection in this, if this matter is allowed.
But this was what nature? What was the sections?
Sections is 341, 149, and 323.
Subsequently charged it under section 341, 147, 148, 325, 34.
Yes, no, sir.
But injury was there.
No, no, sir.
Huh?
No injury was there. And even the complainant was it. He alleged that he was beaten up, but then he did not go to medical. There is no medical report as such.
What is the stage of the case at present?
It is on the stage of this CC.
CC.
Yes.
Charge has all yet not framed.
No, no, sir.
But initially, most probably case was registered under the same section, but subsequently charge sheet is filed under section 141, 149, 320.
Yes, it was.
In connection with this case or the other case?
Now, since Lordship, we have settled the issue outside the court and there was total misunderstanding of
Just want to see the sections quoted here.
Lordship.
Initially for quashing the proceeding in respect of petition in connection with PS case number 1341, 149, and 323. Pending before. You have annexed the charge sheet
Yes, Lordship.
in which page?
That is from page number 18 also, lecture 2.
This is the charge sheet, no?
Yes. Yes. Lordship, it was during the time of election of 2009.
Hmm.
The accused was the supporter of TMC candidate. And there was a Congress candidate also. When Congress candidate, Mr. Kiri, assaulted this supporter of TMC candidate. So against that, TMC party has launched a complaint before the PS Tejo against Mr. Kiri. But when the police did not take action on the basis of that complaint, the TMC party worker, they took out procession on 3rd of October 2009. While they was on this procession, of course, the alleged accused is not the party to the procession. He was standing about 800 meters away from the place of incident. So since the alleged accused, he was the ardent supporter of TMC candidate. So to implicate him, although he was not here in the procession, nor he was the party to that scuffle. So in order to harass him, although he was not there, in the FIR his name was mentioned. Now,
That
all,
means
all,
it was a, this couple took place between two parties only due to some political issues.
yes, yes, only due to some political issues, political differences. So in order to harass him, this FIR was lodged, and after the lodging of the FIR, they have settled the matter outside the court in the year 2014, and in written form, it has been now recently they have drafted this mutual settlement agreement on 14th day of July 2023.
So it is not in the record. I think.
This is not on the record.
So can we be submitted? Copy.
I'll place the original.
Yes. Yes, Ms. Jenny, you do have it.
Paragraph 3, it has
Yes.
clearly mentioned.
Yes, yes, Your Lordship, yes.
Yes.
No, what you're submitting, I
Yeah.
thought you have completed, okay then.
Yes.
Even
This is the
otherwise,
agreement settlement, agreement.
Yes, yes.
even otherwise, your lordship will see they were charged sheeted under 341, which is compoundable.
Hmm.
323, which is compoundable, only 149.
149 is there.
And and 140, your lordship is well aware that in unlawful assembly, there should be 5 and more person,
Hmm.
but then only 2 persons were charged sheeted. However, my only concern with regard to this is that these 2 persons were charged sheeted in this case. One is Nune Time and the other is Cholangso Kora, your lordship. Now, since the agreement is only made by Cholangso Kora, your lordship, even if your lordship is
Yes. What about the
Question.
other one?
He was
Have
also not, in fact, party to the procession.
No, no, whatever, he is also charged in this case.
He's also, yes, that's it.
Now, if your lordship is allowing this petition, your lordship, only with regard to
Yes, yes, definitely. So, what was it, what is his other name is
page number 22, your lordship.
page number? Yes, against. Wait a second. Now you are holding so Kara
Yes,
Yes.
and other one is
Nune time.
Nune time.
Nune time. Na? He is not appearing.
I have thought that even with Nonetai, this complainant has entered into a mutual settlement.
No, whatever, he is not
Yes, yes,
appearing
it is-
for us, he
yes.
can appear fine.
Not on the record also,
Yes.
only in respect of the
Hmm.
applicant petitioner maybe.
Yes, yes. Heard Mr. D. Kamru, the learned counsel for the petition, and also heard Mr. MS TG, the learned additional PP appearing on behalf of state respondent. And Mr. Your good name,
T Taggu.
Huh?
T Taggu
T. Tangu, the learned
for respondent
counsel
number.
appearing on behalf of the respondent number 2 by filing wakalat. This is an application under section so and so for quashing the proceeding in respect of the petitioner in connection with so and so, which is pending before the learned chief judicial magistrate Teju. Teju, Posto. It is submitted by the learned counsel for the petitioner that the present petitioner is no way involved in the alleged offence. However, only to harass him, the present petition was lodged by the respondent number 2. There was some scuffle took between the two parties during the election procession, election time, but during the pendency of the present petition, both the petitioner and the respondent number 2 entered into a mutual settlement agreement on 14/7/2023, and accordingly, considering the mutual agreement between the parties vis-a-vis the other aspects of the case, the present petition for caution may be allowed by invoking the power under section 482 CRPC for setting aside and quashing the criminal proceedings so and so, FIR 30, so and so. In this context, the learned additional PP, MSTGD also submitted that as the matter has already been compromised, the state has no objection if the petition is allowed by quashing the criminal petition, so and so, so and so, so and so. However, they submitted that the present petition is filed only by Mr.
Solisopora.
Solisopora, and hence the petition may be allowed, or the proceeding against the present petitioner may be paused, which is pending before the learned CGM, so and so. Only with the learned experience. In this further, the learned counsel, Mr. T. Tangu, the appearing on behalf of the respondent number 2, also submitted that the matter has already settled between the parties, and out of the mutual settlement, both the parties have also entered into a deed of mutual settlement on 14/7/2022, and hence he has no objection if the present petition is allowed. Considering the submission made by the learned counsel for the both sides, the nature of the offence vis-a-vis the settlement agreement between the parties, I find that it is a fit case to exercise the power under section 482 CRPC for quashing the so and so only against the present petition. That's what allow for it, however, the case against the other petitioner will continue as that. With the above observation, this sense. For record, you can give me a copy of this.
Xerox and notes.
Xerox
Okay.
can be kept in the case.
Much obliged.
If
My lord, may
Yes.
this present appeal is arising out from the conviction order passed by District and Session Court Khonsa, wherein convict the appellant was convicted under section 323 IPC, my lord. Initially, it was charged of
What is the IA for?
IA for the during the pendency of this appeal, the matter has been settled between the parties. So this IA is being filed for invoking of 482 CRPC for quashing him, my lord,
For quashing what?
for settlement. Yes, my lord. Section 323, where convict appellant was convict is compoundable as per the section 323 of CRPC, my lord. Compoundable, my lord. IA has been filed jointly by accused person and the victim, my lord.
Now you are praying appeal to be set aside. Okay, what is the prayer?
Praying for a quashing, my lord,
Conviction order.
on mission order. On settlement, my lord.
Yes, Mr. Prosecution. What is the provision under?
This is an application of the 482. Whereas correct position of the law is 320 subsection 5.
Yes. Because it is the case, it is not a petition, it should be under 482. Quashing what quashing? The order that is not, that is already appeal. No? It is at appeal
No,
stage.
no,
Pending appeal.
Yes.
It
Can be
they were
compounded.
competent.
Yeah, that is not the issue. But the
they can-
question is 482.
Yes.
482 is not, I think not the
320
proper.
subsection 5.
Yes. So better to you do one thing. You withdraw this present IA and file the IA in the proper section of law. Otherwise, 482 cannot be the proper section to grant any relief, even if it is compounded between the parties. Understood? No issue on that. Can be compounded. 482 is not applicable. That is the issue. So you just withdraw this one and immediately file another.
Your Honor, yeah, I'm respondent number 2. I'm the victim.
No. Compoundment regarding the your compromise, we are not going anywhere.
Yes,
There's no issue at all.
yes.
It has already been compounded during the pendency of this appeal.
Yes.
That is understood. That is not the issue, but we are on 482. 482 is not the proper section. I think so, but I'm not sure. He is saying that 323 subsection 5.
But there is a clear provision of law 482 cannot be.
Yes, 482 cannot be invoked in such a situation. So you just withdraw this one. Just I'm submitting. Withdraw this one. Withdrawing this, file immediately the another petition. Another I that can be done. It's okay. So both 20, actually order will be on 23. Mr. K.
D. Tamut.
Yeah?
D. Tamut.
D.
Nova
Tamut.
Tamut.
D. Tamut, the learned counsel for the petitioners, less appellant, and also her Mr. G. Talu, the learned additional VP, appearing on behalf of state respondent. And just submitted. I'm just it is submitted that the petition is filed under sections. This interlocutory application is filed under section 482 CRPC. But due to some technical difficulties, he wants to withdraw the present I. Stop prayer allowed accordingly. The present interlocutory application is disposed of accordingly with a liberty to file any other interlocutory application if necessary under the proper sections of law. With the above observation, the present same. So I'm disposing this one as withdrawal and we take liberty to file any other application which is necessary or in the proper section of law. And in 24, you write so and so, next list. Do you want after 1 week, 2 weeks? After 2 weeks, we'll do? Already
weeks.
compromise?
3 weeks.
Why 3 weeks? 2 weeks?
They are from the long.
List after 3 weeks. The appeal is, we are listing after 3 weeks.
Yes.
Appeal is, we are listing after 3 weeks, but in the meantime,
Yes.
within 3 weeks, prior to the date fixed or whatever, within 3 weeks, we just try to file the I so that it can be tagged with the appeal after 3 weeks.
Yes. Oblige.
Your Honor,
Yes.
here we have filed a civil revision petition against the order and judgment passed by the Deputy Commissioner in case number TS 281/2017. The judgment was pronounced on 12/2/2018. Before
Here we do not require any kind of, I mean, it's a simple petition. No, here we do not require any further record and all.
Actually, I would have submitted that because though in the pleadings, they have said lots of things. Nothing is filed along with the civil revision.
That's why I'm saying,
Yes.
otherwise I'm not the issue.
LCR is
Because,
No records are
there's
filed with
nothing
it.
in the record.
Nothing.
LCR may report.
And she should be called for writing, then it will come to whether your submission is substantiated, all these things. Now see, question, matter is of 2018, it's a long pending one, whole pending. So as per you, how much time will take to call for the record and all?
Come from Alo.
So it will take 3 weeks. 3 weeks will do. Okay, then we'll post it for 3 weeks.
Yeah.
Hard Mr. M. Patil, the London Senior Counsel for the petitioner, and also hard Mr. D. Bhavan, the London Counsel appearing on behalf of the respondent. The case is fixed for hearing, but it is submitted by the London Counsel for both sides that the case record is necessary for proceed with the hearing. Accordingly, LCR be called for. It has to be called for from DC, na?
DC, Deputy Commissioner.
Deputy Commissioner. Deputy Commissioner West Young Alok. Deputy Commissioner West Young Alok. List the matter accordingly after 3 weeks. Because I'm trying to hear the matter, but there is nothing actually in the record.
Yeah.
The petition is not accompanied with any kind of the annexures. So that's why.
Come, it's
Yes.
very difficult to argue the case. Our point is only law point. That we frame is worldly case was before. Starting of the trial, we will frame the issues. We will frame around 30. Not a single issue have been taken while judgment was given. Then apart from that, we will produce there 7 witnesses and 4 witnesses as a defense witness or apply. But
Those were not
single
considered.
statement of the witnesses have been referred.
Not considered.
These are the grounds.
This may be a good ground for revision, but let me
report
revisit it.
report my report.
Okay. After 3 weeks, it
Three
comes,
after 3 weeks.
go for the hearing.
Yeah, we'll look at it.
After 3 weeks.
Yeah,
In 20, also you're appealing?
here
Or-
also, I am the appellant here in this case.
Acha. This is ready, I think, for hearing.
Yes, second appeal.
This is second appeal.
Where the substantial questions of law are already been framed.
Yes, I carry on.
Framed by order dated 15/7/20.
Order 15/7.
But my argument would be there is truly no substantial portion of law in this case.
That's very good. But as per order dated 15/7/2019, now 1, 2, 3,
Yeah.
only 1, 2 and 3 is the three kept open. So 1, 2 are the main substantial question of law that have been formulated by the court. 1 and 2.
1 and 2, no?
Okay.
Whether the proceeding and order, decree and judgment rendered by learned court below is amount to judicial impropriety and injustice. The Honorable High Court by order dated 5/2/2014 in CRPC number 1780/2001, Piconoya versus Legal had ordered to ascertain whether the disputed land was bought by the appellant as per the conversation dated on 30/10/1974, and whether it was purchased. The witness PW Chief Takyum Loi, the full-blooded younger brother of the plaintiff, has admitted that the amounting of rupees 750, which he took from the appellant, and as he failed to repay the amount, the cover was held on 30/10/1924. And
Yes.
And whereas there was no question of whether the sweet land was inherited or joint property of the plaintiff. Now, whether it was joint or inherited, it was not mentioned. When the purchase of land is brought, it was not necessary to go into the whether it was a joint or inherited property. Now, my point, my submission here in the case is that when the land was given, that time the respondent, here in the case, we were the respondent, but we were made as appellant there in the trial court.
But there was no concurrent findings were there or no, it was reversed. Right? In earlier courts, in earlier appellate court or the original court, was there any concurrent findings or
Yes.
concurrent findings?
Trial court as well as appellate.
Yes. Now,
so basically you filed the original suit or the respondent? Who filed the suit? Basically before the trial court?
yes, this case, the present respondent were the complainant. And when the judgment was brought against me, we have gone to the High Court. When High Court has directed to try again, then we were made a appellate. We become appellate. Actually, we were the respondent. He was the complainant. So here in the case, there is no dispute about the taking of rupees 750. There is no dispute about the giving of the land. So there was no objection and claim that this land cannot be given to the appellant, present appellant, by the W. Loi. Now, even in the conversation, which was part of 30/10/1974, the appellant, Lido Loi, he himself is the member of the decision, and he has admitted and he has accepted. Now, this is the whole judgment was given by the trial judge. They have not taken into consideration about the statement and deposition of the legal. The case was between Hikom lawyer versus legal. Then all the witnesses' statement, their statement can be, they can corroborate it. Their statement can be taken as a corroborative evidence, but main case lies with Hikom lawyer versus legal lawyer. Now, when legal lawyer has no dispute about the Kaba decision, which was held on 10/1974, then what is the dispute? There is no dispute. He has admitted the Kaba decision. But in the judgment trial court, they have not reflected anything about the depositions of legal lawyer. Had they taken into the consideration about the depositions of legal lawyer, certainly there is a no dispute. Now, second, whether the categorical admission of statement in cross-examination made by the plaintiff himself can be disproved, nullified by the plaintiff through his own prosecution witness. In fact, if the learned court below has taken into consideration the deposition and cross-examination of the late legal lawyer, it would not necessary to take the statement of the other witnesses. The case was in between Hikom lawyer and legal lawyer, and when the legal lawyer plaintiff himself admitted all facts, the other witnesses' statement would have been taken as corroborative evidence. But here in this case, the statement and deposition of the legal lawyer has been kept inside. In an entire judgment. And as such, the learned trial court has passed the judgment erroneously and wrongly, decreed the disputed land in favor of the plaintiff. Whereas the plaintiff late legal lawyer has not disputed the Kaba decision dated on 30/10/1974. And he has admitted that the handwriting of the Kaba decision was his witness to Kaloi, and he himself put upon the Kaba decision, and he has no new objection upon the Kaba decision dated on 30/10/1974. Thus, the plaintiff himself proved the case of dependent public appellant. Now, that I will show you the proof. I will prove that allegation from the document that come to the statement of legal lawyer.
Sorry to interrupt, but my lord, this is second appeal.
Yes, second appeal.
Deposition.
Yes, second appeal. Because in the ancient judgment, they have no depart the statement of the legal lawyer. Because case was between the Hikom lawyer and legal lawyer.
Now, yes, it can be, I can understand your submission, but the question is, if it's a second appeal, so most probably purely on some the points which have been raised or substantive question of law. Your argument should be raised on that only.
No substantial question is there.
Yes.
Whether without taking into the consideration of the deposition made by the parties, can the judgment be given? First of all,
Was it a substantive?
they should take into the consideration about the deposition.
without taking into the consideration how they have given the judgment, that's why that becomes illegal. Injustice.
Yet your, on 15/7/2019, two, substantial question of law are being formulated by the best bench. Keeping, open for the other things. Now, one is the whether the civil judge, senior division, Alo, by his judgment and order dated so and so, passed in title number so and so, while declaring the suit in favor of the plaintiff, committed an illegality by not taking into account the Keba decision that was on 31/10/2019 as was referred in the order dated so and so, passed by the High Court number so and so. So it is the one of the substantial question of. Another is the whether the additional district judge, Pasar so and so, entitled appeal number so and so, while affirming the judgment and decree dated so and so, passed by the civil judge, senior division, Alo, in title suit number so and so, committed an illegality in nullifying the Keba decision. The Keba decision was nullified by the additional district judge, most probably, as referred in the order dated so and so, passed by the Honorable High Court. So High Court, it was most probably remand back to the district and additional district judge for the decision.
High Court order is different. High Court order is that.
High Court, you have annexed the High Court order is at which page?
High Court order was that.
No, which page? High Court order is in which page?
Not there, my lord.
No.
No, they have not annexed it.
High Court order will be there. Because it was the main thrust
Yeah, that's
from
why
which
I'm asking
the case has come up.
whether it is available in the paper book.
It is available in the paper book, but the paper book is a second agree, it should not have been printed actually.
Yes, it should not be, but however, it is here.
In the paper book. My lord, that's
Petition.
that's the one.
Petition man.
110 to 115.
Oh, fine. Petition man. Hi. High Court order.
There is a member of appeal.
Acha,
Memorandum.
in which page? Which page?
Just a moment. Page number 70.
Karun.
In the memorandum.
Yeah. Oh, page will be the one. Page 17.
Ah,
Page
seven.
17.
70.
Sir,
17.
17. The judgment was pronounced on 5/2/2004. Now, here.
So there were some direction by the High Court. Okay, now yes, you can supply.
No, High Court is for the, in the Paraten, for the aforesaid region, I am of the opinion that for proper adjudication of the said land dispute between the parties, the matter be remanded to the Deputy Commissioner, Wechang District, Alo, to decide the same on merit by affording all opportunities hearing of the parties, both documentary and oral evidence, before the final decision is made. Now, the impute order dated on 14/8/1999, Annexure 6, to the writ petition passed by the Deputy Commissioner is hereby set aside and quote. And the matter is remanded to the Deputy Commissioner, Western District, Alo, for fresh decision, the light of the observation made above. Now, in the para pipe, the use of the material available on record, including original record, it is seen that no evidence has been recorded by the Deputy Commissioner in this case. The decision was made only on the ground that the petitioner has claimed that he was purchased the said land from the brother of the respondent opposite party at the cost of 750. After purchase, the said land was developed by the petitioner into horticulture garden and planted bamboo and fruit trees which are still in existence. The Deputy Commissioner also held that since the matter was decided through an arbitrator as provided under section 30 of the section 2 of the Assam Frontier Institute of Justice of 1945, and on the basis of spot inspection of the land, although the petitioner is in possession of the said land, but he has failed to attend the chicken liver examination and objected to and has made a prayer for adjudication of the case on sufficient documentary evidence and witnesses to prove the case in accordance with law instead of adopting chicken liver examination. In support of the above, the respondent opposite party has also objected to the document which relied upon by the petitioner and alleged that the document was false. Now, here in this case, now, for the document which was produced, that document, whether it was false or not, it was to be decided. When it was not false, when it was found to be genuine, in that case, there is no dispute. Now, Parasit, the petitioner has relied in his case on the purchase of the land from the brother of the respondent opposite party and also on the conversation dated on 31/10/1974. Whether the land was purchased by the petitioner and the decision was made by the Kaba on 31/10/1974 is the question to be examined by the Deputy Commissioner by taking both documentary and oral evidence, which has not been done in this instance. Now, subject matter of the dispute is the decision of 31/10/1974. Now, I have established that I have purchased, and that decision was written. After that, the present respondent, he has also admitted that there was a Kaba decision. When Kaba decision is already proved, in that case, where is the dispute? In the cross, in this case is between the Hukum lawyer and the leader lawyer, but leader lawyer's deposition has not been taken silent. So I am not disputing with the witness. I am disputing the leader lawyer, and whatever allegation I have made, leader lawyer has accepted and admitted. But that was omitted. So without these parties, how the matter can be decided? Because the main basic point, which has to be decided as per the High Court order, the court should decide whether it was a false document, whether it was a Kaba was held or not. But that person has been admitted by the legal lawyer. So how, since 1974 onward, I am possessing the land, how I can be disposed?
That your, as per you, Lido Loyi was not examined.
Huh?
Lido Loyi was not examined. Lido Loyi was not examined. Lido Loyi ne ki kisi Lido Loyi? Lido Loyi, he was not examined.
No, he was examined.
Examined.
He was examined and he has admitted everything.
Death ke baad decision admitted.
He has admitted. Yes, it is in paper book, no paper book. Yeah. Yes. 90, paper book 90. Paper book 90 and come to the page 91 cross examination. Cross examination. When Tomoloi died, I cannot say, but it may be approximately 15 years. I do not know the exact year, but it be 5-6 years back when Martoloi died. During the course of arbitration proceeding, Hicom lawyer produced a Kaba decision. In the decision, it was mentioned that Sri Dagdum Loi sold the present disputed land to Sri Hicom lawyer. I do not know on which date that decision was passed. In front of CEO V. Bagra, during the proceeding of arbitration and subsequently before the DC, Sri Dukka Loi admitted that the Kaba decision was written in his hand, but he simply forgot the date on place where it was written. Admitted. Now, I have not protested the decision produced by Sri Hicom lawyer in the arbitration proceeding. I have no objection upon the Kaba decision, the proceeding. Sri Hicom lawyer is very much elder to me by age. I know that Hicom lawyer is not having any educational qualification. The present disputed case is between myself and Sri Hicom lawyer. It is not a fact that Hicom lawyer, being an illiterate person, cannot fork P Exhibit 1. According to me, the dispute document P Exhibit 1 is written by wife of Sri Hicom lawyer. I have not lodged any complaint against the wife of Hicom lawyer. Whatever I have stated that and Exhibit 1 was written by the wife of Hicom lawyer was a hearsay during the Kaba proceeding. I cannot differentiate the handwriting. Exhibit 1 is other handwriting of Dukka Loi or the wife of the Hicom lawyer. It is true, while Kamdup lawyer was proposed to marry with Yumi Loi, Sri Hicom lawyer gave Devo WRC to me, and I also exchanged one WRC which was belonged to Hicom lawyer. As I failed to give WRC fee to Hicom lawyer, my son Sri Jomkar Loi paid ₹9,000 to Sri Hicom lawyer. The Devo WRC fee has no interlink with the present disputed land. I made a complaint to stop the cultivation at the Panda land before DC allowed. I have particularly opposed the cultivation of Hikomnoya at disputed Panda land and lodged complaint before the DC. I do not know that the decision paper do not maintain diary. So I do not remember what things I have done illegally. It is not the fact that the term impression which was put against my name is known to me. During the course of arbitration, I have not met Sri Marley lawyer as my partner. I do not remember attendance before the deputy commissioner in connection with this case. It is not the fact that whatever I have stated today are false, and in spite of giving the term impression on paper against one, I am denying the fact. Now, subject matter of dispute of the case is whether this kebab was held or not on 31 October 1974. Now, where is the dispute? He has no dispute. Even he told that the kebab is a rule of detail. It was the handwriting of Dukkaloi. And he has stated it before admitted it before the arbitrator. He has admitted it before the deputy commissioner. Then what is the question of project? When there is no project, when it becomes a value, in that case, the decision and judgment should be given as per the Kebab decision which was passed on 31/10/1930. So there is no dispute. I have not filed the case against any other witnesses. I have filed against Lidoloi. Then when Lidoloi himself admitted the document on which I am claiming the land, then there is no dispute. In spite of that, why I should be disposed? Since 1974, I possess the land. And can there any judgment can be passed without taking into the consideration of the other parties' statement, deposition? Here in the judgment, where they have passed, they have completely silent. So that becomes a question of law. And the witness's statement only used for corroborative, whether it is supported or not. But here in the case, the main party himself admitted and accepted 31/10/1974, and that document has not been set aside in court until and unless the document has been set aside in court, and the document has come up to the High Court also, and High Court has directed whether really it was purchased or not, whether the decision was a genuine or not. So on the basis of that, the case is to be decided. Therefore, the judgment which was passed by the Civil Judge Senior Division, West Yang Law, which was passed on which was passed on improved order and judgment and decree dated on 7/6/2019, passed by the learned additional district and session judge, La Parada, Siang District, AP, in Basar case number 2/2000 Sri Hikomloya versus Sri Jumkaroli. And judgment decree and order dated on 9/5/2018, passed by the learned civil judge, senior division Alo, Quechar district, AP, entitled suit number 04/2016, during the pendency of the, it was the judgment. Initially, this case was tried before the additional deputy commissioner Alo. Then during the pendency of the case, then the question of the separation of judiciary comes. Then again this case was transferred to CGM. That is, the case was initially heard by the CGM. That is senior civil judge. After that, the judgment was, case was heard and date of judgment was also fixed. We appeared without giving us the judgment copy. Verbally, he assured, he has pronounced in front in the court that judgment is posed in favor of the Hikomloya. In the court. Then, but no judgment was given. After 6 months, he has pronounced judgment. When the judgment copy was served to us, it goes against us. Then again from that.
This kind of submissions, my lord.
No, no,
as
no,
the
no,
expressions
no,
of the
no.
judicial officer
No,
saying that
No,
in open court, he said if
I'm telling the
in
fact,
favor.
background of the case. After that, we met an appeal before the additional district judge, Basa. Then now I am challenging that's why this case becomes the second act. Because from the trial, there is CG from the senior civil judge, CGM, he has pronounced the judgment against us. Then again, we made an appeal before the additional district session. Then the additional district session judge also affirmed the judgment given by the senior civil judge. Then we have come here in the case as a second act. So now the simple matter that substantial question of law is that when both the parties are fighting, when the other party is admitting whatever allegation I have made, then what is the question of dispute? Judgment, how the judgment, how, no doubt, they are, our case, generally start from the decision of the 31 October 1970. Nowhere they have set aside the judgment, which was passed, which was passed of 31/10. But when it becomes bona fide, when it becomes admitted and accepted by the other party, in that case, dispute is already settled. Now,
On that basis, why?
now.
Yes, on
That-
that basis, why didn't you approach the court?
Huh?
That matter has already been settled, there is no dispute at all. So it could have been disposed of on compromise degree also, if that was the position. If that was the position that other side also admitted regarding the Kaba decision or regarding the land dispute, whatever.
Yes,
If there was no dispute at all, then
Huh.
in that case, both the parties could have.
yes, it was because
No, have you approached the court with any compromise?
no, it was to be, and that's why while the date was fixed, just told us that judgment is called immutable, unaltered. But no written judgment was given to us. Verbally, it was in our favor.
If the officer has done such thing, it is very bad because in civil matters especially.
And now
should
what
not
I'm
be
thinking,
pronounced before giving ready.
what I'm,
I don't know
what I'm thinking is that whatever I have made a submission before the court, had he written his judgment at time of after the case, he could have remembered all the facts and circumstances of the case. Because judgment was pronounced after long gap. So I think he might have got confused. He might have not been remembered.
Whatever be, all the materials are available in the record itself.
But
Can it be taken up some other level that understanding also is more definitely prepared and comes in a sequential.
yeah,
manner.
first of all, to go to the judgment against me, they should nullify the validity of the cabatis on the test of 31st They are not setting aside the cabatis. That means the land becomes two owner. As per the 31/10/1972, I have found the procedure. How I can dispose this? And that fact has been admitted and accepted by the opponent party. That is my point.
What?
No, no, it was no washroom. His concluded his argument.
Huh?
His argument has been concluded.
Concluded?
Yes,
Over?
yes.
Okay. So you are here?
Yes,
So what I have understood from his submission that one Keba decision was there in 1974. That was not being challenged and it was accepted by the parties. And regarding his position of the land and there's no dispute at all. So that is the submission more or less. So, and most probably the evidence from some witnesses were not taken into consideration while passing the order. So that is the almost.
All day I will have to read the whole judgment now. Trial court judgment. My lord knows, even if there is an error in the finding of fact, in the second appeal, you will also be known. But the manner in which the argument has been placed, I am now in a position, I will to read the whole. Our 1974 has no consequence to us. There was a land sold by somebody to him, that which he claims to be. We say there is a different land. The present disputed land is different. PW3, why don't if your lawsuit goes to the trial court judgment, everybody's position has been taken into account. It's a long judgment.
But what about the Keba, one Keba decision was there?
Keba is not for this.
Yes, not for the land.
Not for this.
Now he is saying that he purchased the land at rupees 750.
That's
But
why.
as per you,
That's why.
that is not the disputed land.
No, that is not. Taking all this into consideration, other trial court has come to conclusion. Now I'm in a position, I will have to read the whole trial court judgment.
So you want to read some other day or what to do then?
It will be better,
No.
my lord, because the main is in the second appeal is being argued.
Yes, yes.
Typical thing.
The second appeal only.
Yes. Because it is a, start from page 17. And said, my lord, it's a 41 page judgment. And then
Long
also-
judgment.
Long judgment. Everybody was, everything was.
No,
taken into account.
otherwise, some and substance of the matter was originally you were the appellant in the original.
No, I'm the plaintiff.
Sorry, yeah, you are the plaintiff.
Yes.
Ah.
That land that he was in occupation of, we had an actual relationship, good relationship. My son was to marry his daughter. Ultimately it fell off. At that point of time, when his relationship was there, I allowed him to construct a granary in this disputed land. It is on that basis he has played. And the latter trial court is complete finding, or is only at that point that he has taken.
All these matters already
Yes,
been considered.
74 is, latter trial court has come to finding 74 is not part of it. That is the. And the High Court direction also, my lord, the issue was also settled in a manner because it was argued clumsily. I don't want to say it in senior, but the first issue is also not correct. Because High Court never directed. High Court only directed you take evidence properly.
Yes, yes.
That is the only direction. The first issue.
That
may
was
not-
direction to the DC, I think, but subsequently the change of
Ultimately,
so
ultimately, civil justice.
civil just senior of the document.
He said the legal law was not examined. That is not correct. Your lordship there. Page number 32 of the memorandum of appeal.
Page number 30.
2 of the memorandum of appeal. This is the part of the judgment.
Yes. I believe Nidaloyi was examined as PW3.
Yes. It could be the fitness of things, my lord, that documents are so to buttress what the London Supreme Council is arguing. After all, this is second again. It
Yes,
should be of this, the substantial portion of law, why. He was examined, man. Otherwise, since my lord is sitting next week also, can it be taken up Wednesday? Wednesday? So that my lord, can see your lordship better. Because the land is not pointed out exactly what it. The manner has been argued now from this judgment, I have to read the judgment now because I said that these witnesses were not taken into account. It cannot be there in the letter. I was examined, I had PWs, everybody's statement is recorded. That is how it has come to a trial court. Defense witnesses were examined, even the defense. If it is possible or otherwise, kind of some other process, because we're not sitting on only next week.
Only next week, I think. Well, pass the order, I won't pass any order on part her.
Yes.
I'll list the matter after one week, I'll list. After 1 week. It may come either Wednesday, Thursday, or even if next Monday also. Let us see, because there is some engagement also.
Yes, yes.
So.
Not partner. but only-
Not partner. So her so and so which will have list the matter accordingly after 1 week. Let us see if 1 week.
Yes.
We'll
Because-
talk to the registry also if it can be possible.
my lord is
possible
seen
by
as-
secretary.
I don't want to say this.
No, I'm just
Yes, so-
confused also
Yes, yes.
because
After this appeal,
hmm,
now your lordship has seen the substantial question of, it is like a revision petition, it is not a substantial question of law. Supreme Court is categorical. Supposing the London trial court, there is an error in the finding of the facts. It's law, settled law. New judgment has also come on that. First judgment is necessary before.
hmm.
The next day, hopefully, I think London instruct us.
You just one thing, because it is a second appeal,
Yes.
as we know. So second appeal, basically, there are some points on law or. So in that case, and as that also, there is a concurrent against the concurrent findings we have come. So exclusively, there should be a law
Yes.
points in there. So law points you can elaborate, you can submit as per you. Other facts at this stage most probably,
Yes.
yes, to some extent may be considered, but otherwise as a whole. So any brief in a manner, it can be submitted, otherwise it will be difficult on our part also
Yes,
to
yes.
submit it.
You have to assist the lordship
Yes.
better.
Yes, yes, in that case, otherwise I'm a bit confused by the
Yes.
argument, because he is saying on that some issues like not examination of so and so, these are may not be the issue, I think.
Yes,
So-
BW3 has been examined.
Yes.
It's legal law is there.
And their basic, as he has submitted, their basic question is that the land which are you even possession is not the actually the disputed land. Disputed land is otherwise which
Yeah.
the was that there
That
was
is
a.
the finding of the London
findings
trial
of
court.
that. So let us see on the next week. We'll list on next week. Yes.
There was recent judgment 2020-19 SCC 57,
Hmm.
which is now been cleared now.
Hmm.
No appreciation of evidence.
Yes, I should not. Unless some. Twenty-five or 26. So now you have filed one IA here.
Hello, there are some typographical mistakes in my CRP. Malad, there are 4 respondents actually. But inadvertently, respondent number 4 has been referred to as respondent number 5. And
Actually, there are 4.
respondent number 4
Ah,
has been referred to as respondent number 5 mistakenly. Malad. And
next.
the, In page.
So there are, as per your CRP, 1, 2, 3, 4, 4 respondents are
Four
there.
respondents are there.
Actually, there should be.
It should be four, respondent number four, but mistakenly it has been referred to as respondent number five.
Where in your CRP?
Yes, in my CRP.
But
Your Honor, may I take
I
up my?
don't know, here the 1, 2, 3 and
No,
4
Your
are
Honor,
there.
in the paragraphs,
Oh, it's a paragraph. Acha,
Yes.
okay, okay.
In
In
the
which is
par-
para you say?
yes.
Para number?
Para number 5 and 8, And-
Para number,
5 and 8. Your Honor, will find para 5,
para
in page
number
number
5.
7.
Yes, in para number 5.
Third
Respond
line,
number 5, yes, first.
in third line.
line.
Yes,
Okay, respond number 5 and then
and then in,
para number 8.
no, in 5, there is also another respondent number
Okay,
5
yes,
in
I have
same
seen,
para.
yes, yes.
And in page number 8, para 8, page number 8, para 5. There is also respondent number 5,
In para
On-
8 also, or?
page 8, para 5 only. Next
Eight,
page,
okay,
just
okay.
next page.
Para 8. No. Para 5 is in page
Para-
number 7.
7, it continues till,
Yes, one number 5. Okay. And
and
then again?
in para 8,
Hmm.
Your Honor, second last line, Respondent number 4.
Yes, yes.
it appears in synopsis as well, Your Honor,
Oh, in synopsis also.
synopsis also. In second line,
Hmm. Respond
between the
number 5.
petitioner and the
Ah,
respondent.
Yes, yes.
And in midline, my lord, there is one sentence, the petitioner has already made repayment of a total sum of to the respondent
Respond
number
number 5.
5. And just below that also,
Yes, yes.
thereafter, my lord, there is another mistake. It is in cost title.
Cost item.
Respond, yes, in the list of respondents, in respondent number 2. It is supposed to be all 0 Gaon Bura and Gaon Buris. Gaon is.
Gaon is missing.
Yes, it is occurring in several other paragraphs, Your Honor. In 3 also. I have mentioned all the pages where this has been omitted. I may be allowed to make correction of these.
But there are several corrections will be there, na?
Yes.
So.
As for the
What is the
notification,
procedure
as for the notification, my lord, notification dated 19 June 2023, I have to file a fresh amended pleadings.
Yes,
I will submit it to the registry.
yes, because this is a notification. After that, we are not allowing to make any correction through hand,
Yes,
by hand. So that is the now the
Yes.
condition, so.
my
we have
lord
to
may
file.
allow my prayer, I will submit the amended pages to the registry.
IS, this is item number 26, the IS 26. IS 25. Part URMS
M. Karva.
and Dabang, the learned counsel for the petitioner. So this is an application for making correction of some topic typographical mistake in the civil revision petition number 40/2023. It is submitted by the learned counsel that inadvertently in the civil revision petition, the respondent number 4 is mentioned as respondent number 5 in several paras as well as in the synopsis of the said revision petition. Further, it is submitted that in the cost title of the petition also is inadvertently referred as mentioned as in the respondent number 2 is mentioned as all 02 Gaon Bura and Buris Association instead of all 02 Gaon Bura and Gaon Buris Association. And the same mistake has also been taken place in other pages, particularly in para number 1, page number 1, 4, 8, 9, and 10, and as well as in prayer portion as well as page number 13. Accordingly, prayed to that the petitioner, accordingly the petitioner is free to correct all these typographical mistake, which was due to inadvertent mistake of the petitioner. Heard, prayer allowed. Accordingly, the petitioner is hereby directed to file a fresh, corrected, or / amended petition along with the synopsis for the registry, and registry will do the needful accordingly. The present I stands disposed of accordingly. Let the civil division petition be listed after the filing of the corrected / amended petition. Okay, it will be disposed of. You make the correction immediately.
Your Honor, notice has already been issued, returnable within 3 weeks.
In that case, if notice is issued, the notices were also accompanying the
No,
petition.
notice has been issued, but steps has not been taken. Notice was issued only day before yesterday. So we checked before sending.
Okay. Then you, do you want to file the notice? Actually, notice should be accompanied by the petition also. But
Yes.
you have not submitted any such.
No, it has not been submitted. No, steps has not been taken yet.
Okay.
Therefore, I have.
Then
filed.
help for 2-3 days and file the corrected one, and then you are appealing for the other side.
Yes,
No.
it's for the respondent.
How?
State.
Oh,
State
state, sorry. So they have some, now some corrections and
Notice.
amendation. So we have already allowed, it's a hard for it, hard for advocates also. So have allowed, then the state should be taken, and you will be also provided with a fresh copy or amended copy of the petition.
So Your Honor, but here, all matter has been heard and already interim has also been passed. So it will be taken up again.
No. This, your amended or fresh petition will be
Yes.
tagged along with this so and so only.
Yes.
That much only. Otherwise, earlier what we used to do, make it correction by hand and then petition over here. But here in the, like the lower court or the like trial court, where there also if the amendment portion is quite big or lengthy one. In that case, we used to file a separate amended petition or amended claim. It's similar in the manner, it will be amended petition, we will tag with it. Order will be there itself. It's no problem. No issue.
Obligation.
Or rather, we can mention it will do. Oh no, it's okay. We have disposed this one, and this petition with this disposal order will cover the other one that we have already allowed the amendment or the correction.
Yes.
So it can be allowed.
So we'll take this after I give the amended petition, I will take the steps for.
Better to.
Yes.
Better to take steps. Otherwise, these are the clerical or typographical mistake only. It will not affect the merit of the case.